All right, so you are Mr. Etchelberger.
Yes, sir.
Sir, you're charged with two cases. You're charged with interference with the duties of a public servant. You're also charged with criminal mischief. In those cases, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Okay?
Thank you, Judge. Judge, law enforcement officers were dispatched to a disturbance call in Harris County, Texas, and made contact with a complaining witness who stated that on April 28, 2025, she observed a prior resident, the defendant, cause damage to the apartment complex after a breakup with a significant other. The complaining witness stated that the defendant broke 3 flower pots and damaged 3 trash cans for a total of $405 worth of damage. On April 29th, the defendant came to the leasing office and demanded property. I believe that was left. The complaining witness asked the defendant if he was the one that caused the damage. The defendant stated he was not. Complaining witness and a witness then tried to get the defendant to leave due to him causing a disturbance. Defendant pushed his way through complaining witness and a witness. A law enforcement officer on scene serving civil papers attempted to detain the defendant. The defendant was able to get away and run from that law enforcement officer. The defendant was later detained when other law enforcement officers arrived on scene.
So the mischief, it's at an apartment.
That's correct, Your Honor.
His apartment?
I believe he was a prior resident of the apartments, Your Honor, and the property belonged to the apartment complex.
And that was my question this morning, Your Honor. I haven't stayed in an apartment in a long time, so typically apartment complexes don't give their property at a residence specific apartment complex.
You mean furnished?
Furniture, it's flower pots. I mean, why would an apartment complex have their flower pots out in front of a resident's apartment?
Okay, what all was allegedly broken again?
3 flower pots and 3 trash cans, Your Honor.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner, the leasees, the people that lease the actual
Because
premises.
if it belongs to the other person, then it's a criminal mischief. You can't break someone else's property.
But he's not the complainant. The complainant is the leasing manager for the apartment complex. They're alleging that the property belongs to the apartment complex.
Your Honor, from the DEMS, it says that each 3 trash cans were $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8, causing the property to...
So it's like, it must be, cans that officers put out there in case anyone needs to put trash.
Before this hearing even gets rolling, the court is already trying to untangle a messy situation. What started as a disturbance at an apartment complex quickly escalated into allegations of property damage and interference with law enforcement. But here's the key legal question. Who actually owns the property that was damaged? Because in criminal mischief cases, ownership matters a lot.
The deputy there who was serving some sort of civil paper.
Sure.
And that he had to stop serving the civil papers to go
To chase him.
the defendant, because the defendant, there was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the papers.
Correct.
It's not really clear from the information, is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, John. Richard and I spoke about that this morning.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers.
I think I agree with you on the interference,
Yes, Your Honor.
but I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward on the interference. I don't think that they had a reason to, have you in custody or for you to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Eichelberger, the only thing I'm going to ask you now, or I'm going to order you, is not to go back to this place, not to have contact with the complaining witness.
I
You understand?
Yes, sir.
I'm also ordering you as a condition of your bond, not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail. You
understand.
become a danger to my community. It's not going to go well for you. You understand?
Yes, sir.
Okay. So for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it. And then after that, you're free to go.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you.
All right. Good morning, Ms. Gonzalez.
Good morning.
Ma'am, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness stated the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank the beer. The complaining witness texted the defendant about her being in the residence, and the defendant responded with threatening messages that said the defendant will slap CW and show up slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man. Or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute.
Sure.
Okay, what was it said exactly again?
Judge, the message that the defendant sent to complaining witness states, exactly, bitch, don't talk out your ass because I will go to your house and slap you in front of your family. I'll even come to your job.
That's not imminent serious bodily injury. Come on. All right, I'm gonna find no probable cause, ma'am. As the old adage says, sticks and stones, right? Words will never hurt. They actually can. You have to be careful what you say, who you say it to, because it could end you could end up in hot water. I'm gonna find no probable cause in this case. You know, the idea also is that if you don't have a good relationship with someone, it's probably best not to just inject yourself repeatedly in there because you're asking for trouble, you know?
Right.
I mean, you now know. All right, man, please, just be careful, all right?
Your Honor, I'm filing dismissal.
Thanks. All right, ma'am, your case is being dismissed. If you want to copy the dismissal, you're free to wait, otherwise you're free to go. Okay. You are here, Guzman?
Sir.
Mr. Guzman, you're charged with two cases. You're charged with assault of a family member. You're also charged with driving while intoxicated. On the assault case, you're facing up to a year in jail and or a $4,000 fine. And on the DWI, you're facing up to jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 29, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle with an expired registration and initiated a traffic stop. The law enforcement officer made contact with the defendant driver and observed a strong odor of alcoholic beverage. The defendant admitted that he had an open container of an alcoholic beverage in the back seat and admitted to drinking 2 to 3 beers.
While driving?
It's not clear as to when the drinking occurred. I'll check further in the dim summary. The law enforcement officer found an open 16-ounce Miller Lite can, half empty and cold to the touch under the driver's seat. The law enforcement officer observed the defendant to have unbalanced and a strong odor of alcoholic beverage. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant consented to providing a breath sample and blew a .112 and a .111.
Okay, now we have an assault, right?
Yes, sir, that one is open. And we need
Whoa. Whoa, so that was an open case.
That one was a open warrant for a few months. A non-arrest.
Okay, do you mind reading me what happened on the assault, please?
Absolutely, Your Honor. On March 1st, 2025, in Harris County, Texas, officers were dispatched to a family assault. A law enforcement officer met with the complaining witness who stated that the defendant is her ex-boyfriend. The complaining witness stated that they got into an argument over the complaining witness's inability to make him a sandwich. The complaining witness tried to stop the defendant from leaving, but the defendant closed the door on her hand. Later, the complaining witness was holding her child when the defendant bit her, causing bite marks and a bruise. The complaining witness stated that the defendant has assaulted her before, but she never reported it.
Mr. Guzman, I'm going to find that there's probable cause to go forward with your case on both cases. I am ordering you can you look to see any prior DWIs, please?
Yes, Judge.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I would think that it's freaking elementary that you're not to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason. I don't care where you have to go. I don't care what you have to do. I don't care that you have to work. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. If you do, every single time that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand me? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case. Get to know it, because if you do something to violate the protective order, the state can and probably will file additional charges against you. A violation of protective order, and that is the capital murder of misdemeanors. Mr. Guzman, I'm going to protect every single person in this county, whether they're on the street, whether they're on foot, whether they're on the house. And if you become a danger to my community, I only have one place for you. And I don't know who you have in this life, but if I put your bond at 10 to 20,000, if you don't have anyone to pay it, you will be stuck like Chuck in there until these cases are over with. Do you understand?
Yes, sir.
Any prerogative, yes?
No, Your Honor.
Okay. Mr. Guzman, do you have the ability to hire a lawyer? I can have you fill out an application. I need to know everything about you. How much money you have coming in, what you're doing, what kind of car you have, any kind of retirement. I need to know everything about you, and then we'll take a look to see whether you qualify. Don't be a danger. Do you understand?
Yes, sir.
You get no more warnings. All right, Deputy Miranda. So we have Mr. Rooker.
Yes, so we have,
You have what?
we've done the paperwork for the deferred.
Okay. Is that what you want to do?
Yes, Your Honor.
Okay. Mom and Dad, you can come up. Thank you so much for coming, guys. You know, you're entering into a very, you're entering into a very serious agreement now, Mr. Rooker. And if you think that the way that you've acted while you're on bond, it's gonna work like this while you're on probation, you're very mistaken. It's not going to. I'm telling you now, the agreement that you enter into, while it's great if you can complete it because you don't end up with a conviction, you give up nearly every right known to man by entering into this deferred. If you violate any condition, you are looking at an entire year in jail. Do you understand? So is he living with you guys now?
Yeah.
Because I can't do this alone. While he's been on bond, it's been a veritable nightmare, trying to even get him here. How are you going to be able to make this when you can't even make it to court?
So his situation has drastically changed. He has gone to inpatient rehab. He is currently in outpatient supportive treatment that he attends 3 times a week. He's been opioid free for 6 months now. He is working. He has his own vehicle, so things are very different. And he has moved back. So,
If I send him for a drug test now, what's going to happen?
I'm gonna show it for THC. But I'll make sure.
Unacceptable. No means no. I'm going to tell you, I want to send him to Shiraz today. If you test positive one more time for anything, you will be looking at an inpatient rehab facility in the jail. It's a minimum of 9 to 10 months. If you respond well to treatment, you could be in there for about a year and a half. If you continue to use. And I don't care what it is, whether it's CBD, whether it's oil, whether it's a vape pen, whether it's pills, whether it's a joint, I don't care. No means no. Do you understand? Mind over matter is what it amounts to. I cannot comprehend how you can let this thing take a hold of you so much so that everything else falls by the wayside. Mind over matter. That's what it's about. And if you ever have the feeling where I'm going to use, you either get in contact with us, you get in contact with probation, you get in just if you use, it could very well cost you about a year and a half of your life next time. Do you understand?
Yes, sir.
Your Honor, he is receiving,
Suboxone is only something to prevent withdrawal, so you don't go through the madness of withdrawal.
He's
All-
he's consistently on it through his outpatient treatment because his habit was so bad.
What was the drug of choice? Oxy?
Practicing is fentanyl.
You know that all you need is the little amount of your pinky, and it kills you. I can't tell you how many people we've had here that continue to take the pills, continue to take it because the tolerance builds up and you end up killing yourself because you put your lungs to sleep. That's what you do. Not to mention, it's expensive to even do this. How are you even getting the money to do it? Are you working?
So,
What do you do?
This might sound like a small issue, just flower pots and trash cans, but legally, it's not about the value alone. Criminal mischief hinges on whether someone intentionally damaged property belonging to someone else. And right now, the judge is digging into that exact detail. Who owned the items that were broken?
You hang out with the wrong crowd, you're going to end up doing the same thing.
We currently have no other curfew.
Now it'll be a part of the probation though, so that he has to adhere to it. And will adhere to we can make it a condition. Anything that you want, we can put it on there as well. So no weapons. If you know of a certain person that he's not supposed to hang around with, let us know. We can make that a part so he's not hanging around with these people. Can't go out at night, no going to any parties, no going to any bars. Hanging out with people who are either convicted felons or of a bad character. So I will let you guys get with Shatoria, you let us know, and then we can make it anything. What do you think is the appropriate time he should be home?
So we had him on, during the week, a 12 o'clock schedule,
At midnight?
yeah.
Oh, no.
That's only because.
work.
He works.
Get off at 11.
So,
Houston Community College doesn't say open until 11 o'clock.
but
Some,
he has a
well,
lot of
afterwards.
girlfriend. But some girlfriend,
Yeah, but afterwards, like last week with the events, some days we'll stay after.
not often, but there are times where they have events, but typically the building.
You will have to show what the event is, the time that it ends, and then you get approval. But 10 o'clock is your curfew. I don't want you to at 10 o'clock. You take baby steps to earn trust. Trust isn't something that we just give to you. You have continually broken our trust. So I don't want you to do anything to drive you back into the old Mr. Rooker, because it's unacceptable. And the only thing we want is we don't want you to kill yourself. That's all we want. Everyone here, you have a lot to live for. Life is great. The more money you have in life, the better life is. You get to buy nice things. You get to take nice vacations. You go on a cruise. wherever it may be, Hawaii, wherever it may be. But that only happens with money. And you get money with education and with knowledge, not what you've been doing. The agreement that you have worked out is a 13-month deferred. This is a type of probation that, like I said, if you complete successfully, you do not end up with a conviction on your record. But like I said, you give up the right to a trial, compel witnesses to testify on your behalf, confront, cross-examine your accusers, right to be arraigned. You give up the right to appeal. So once you enter into this agreement, you are stuck with this until you either complete it successfully or you violate. You violate this agreement, I'm going to issue a warrant. I'm going to put you in custody, bring you back out, and we're going to talk about what you did to violate. And if you could be looking at an entire year. Do you understand? For you to complete this successfully, you must do a TRAS. This is an evaluation to see what other conditions you may need. If they assess supportive outpatient treatment, if they assess inpatient treatment, I don't know. But you understand. No drugs, alcohol, random testing, $100 one-time donation to the family violence provider. You just do Houston Area Women's Center. No weapons, and no harassing, threatening, or abusive contact with Guajardo. Curfew 10 p.m. to 6 a.m. You must also do what's called the Batters Intervention Prevention Program. This is an 18-week class that you must go once a week for 18 weeks. Do you understand? The worst possible thing you can do is just take off. That's an immediate warrant. We can always work through any problems, and it's never about the money. I don't care about the money. It's you doing what you're saying you're going to do, staying out of trouble, and be nice. It's not hard, especially with these probation officers. You go to a probation officer, you make your appointment at 3:30 in the afternoon, you go over there, they're already going to be stressed out because they deal with all these other people. You go in there with a bunch of issues, it's probably not going to go well. You understand? Anything else you think that we should address? I'm going to waive all the fees, so it doesn't have to pay for anything. With regard to if they do any kind of like intensive outpatient, I'd like to try to qualify for, funding.
Yes, sir.
We're going to try to keep everything to a minimum as far as money, but you test positive. Do you understand? I want him tested today, and then let's test again in 50 days.
Okay.
I'm testing you again in 50 days. If you test positive for weed again, you know what happens. Do you understand? How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty, Mr. Rook. I'm going to withhold that for 13 months. As part of this agreement, the assault is going to be is dismissed, right?
Yes, Your Honor.
All right, Mr. Rooker, I wish you the best of luck. Make it work. Okay? All right. Thanks, guys.
Thank you, Your Honor.
Okay, you are Kevin Vasquez.
Yes, Judge.
Mr. Vasquez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Yes, Your Honor. On April 14th, 2025, in Harris County, Texas, law enforcement officers assigned to a follow-up investigation for failure to stop and give information. Complainant advised law enforcement officers that the defendant pulled out of a parking spot and struck the complainant's vehicle in a Chick-fil-A parking lot. Complainant advised that the defendant left the scene without providing any information. Law enforcement officers went to the Chick-fil-A and found surveillance footage of the incident. Store manager stated that they recognized the defendant as one of their store employees who was on shift that day. Store manager provided the defendant's contact information. Law enforcement officers arrived at the defendant's residence and spoke to the defendant's mother, who confirmed the defendant had been driving the motor vehicle that day, but her husband was the registered owner. Defendant contacted law enforcement officers, provided his Texas ID and insurance information, and admitted driver of the motor vehicle on the date of the accident. Defendant stated he drove out of the parking lot and felt an impact did not see anything on the ground, so he left and went home. Defendant stated he did not call the police or file a police report.
Okay. Can you run his license, please?
Yes, Your Honor. And one other thing, Your Honor, we did get a damage estimate back, just for the damage purposes.
Oh, how much? Right.
$5,000.
It's,
But we've.
yeah, we've talked about that, Judge, and we've watched the video and there's a lot of pictures of the
I mean,
damage.
it always depends on the car.
That's exactly correct.
Lambo.
That's why. It's an Audi, but it's a 2013 Audi. So I don't know, and it may be. So we'll figure it
I
out.
think we'll be able to help. But
Insurance?
I'll find out. I don't know if he has insurance, but I'll
so
find out.
according to the DIMS, the defendant had turned in insurance information over to law enforcement. I'm going to talk to the complainant, see if there was anything filed, and maybe we do something with the deductible.
Sure. Do you see if he has a license?
Yes, Your Honor, I'll.
You're not allowed to drive, Mr. Vasquez, unless you have a valid Texas driver license and liability insurance in your name. That is a part of your bond condition. If you pick up another case, if I find that you're driving without either, I will revoke your bond and put you in jail. No more PR bonds. Do you understand?
Yes, Judge. It's eligible, Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with Marcos and he'll tell you if and when you have to come back to court. So do you mind filing those conditions and then we'll sign it? We're going to have conditions for you to sign. Once you sign the conditions, after that, you'll be free to go.
You're right, that's just they're driving without a valid Texas license and
And
insurance.
no insurance, right? So we need a bond because it's in warrant status now. Roxanne, do you mind giving me a PSR? And do you want the cause number? You have it? Okay. I don't know if I see anything. If barring no criminal history, I'll set the bond at $100. I'm going to give you a PR bond now, but like I said, you will not get any more. This is your one chance. You understand?
Yes, sir.
Are you still employed at that Chick-fil-A?
Yes.
Okay, good. Okay, so he's gonna have a ton of paperwork to sign. We'll have you go to Victoria Sign and Reset now. Do not leave until you sign our bond conditions, then you have to meet with Roxanne for your PR. Okay, thanks, Mark.
Appreciate it. Okay, just.
We're approaching on Miss Torrance. She's in custody. They did the T-RAS, we got the report. They are recommending, and Judge Torrey, maybe keep me honest here. Which they're recommending residential treatment, but community, which means that she would have to pay for it. And just to be completely candid,
Doesn't have insurance.
no.
She's not gonna be able to pay for it.
Yeah.
The alternative to the residential is by another adult caseload, since you report 4 times a week, and then going to I that's right, the other version is on the page. But this time.
What do you think?
Well, I understand that the DWI YA is probably a good program, but if she has to report 4 times a week, that's setting her up for failure because she's not going to do the work. Because no employer is going to let somebody take off 4 times a week.
But so reports.
I'm gonna assume they screened her for sober report and maybe she didn't meet the recommendations.
How not? How would she not? I mean, really?
Her BAC was like 0.62, denied any use since November 2024. So based on what she, I don't know, based on what she's telling the assessors.
It's completely just.
Just to give you a little, what is kind of putting state in a wrong position is the BAC was low. We assumed there was going to be something with tox. Tox still is not back, and I think people are rightfully slow, suppressed it because we still don't even have the lab back yet for the tox. Blood alcohol.
And when could you possibly get that back?
So
When's the last time you reached out to
I
them?
talked to them yesterday.
What'd they say?
No defensive conflict. And the reason we were reaching out was Anna had filed the trial packets, the blood alcohol trial packet. They would refuse to release that to her because they're not done with their analysis. I then called, maybe the state
It's
called.
really unbelievable how so many cases cave just because we can't get labs back. It's mind numbing just how justice has to sit and wait because of the labs just can't get their shiesty together, man.
Well, and Judge, just testing for tox is a little bit more complicated because one person tests for cocaine, another person tests for the benzodiazepines, another person tests for opioids. So it's not.
Don't just put in like.
Here's where the legal nuance comes in. The judge is separating two charges, criminal mischief and interference with a public servant. And the standard for probable cause isn't very high, but it still requires clear evidence. If the officer had no lawful reason to detain the defendant in the first place, then interference simply doesn't stick. That's why you're about to see one charge survive and the other collapse.
Turn over what happens without the full analysis being done, which has not been done in the.
What do you want to do?
I mean, even without the blood packet, I think it's a good trial case. But I would like the blood packet, obviously, to see, if there's any issues with the blood and maybe it's not a .06. Maybe it's.
I've already suppressed it, haven't I?
Well, no, you just suppress the tox, not the blood alcohol. Because we had the blood alcohol come back. The policy is if it comes back at 1.08,
And they sent, right. Okay, so we have the blood, but the blood is only at what, a .06.
And we just have the report. We don't actually have the full, like, picture of the vials, chain of custody documents, all of that Anna and I would both need.
Right.
To try this.
If you want to do the probation, right, I'm certainly okay with it, but I think that's probably the best way. I don't know.
Well, with Furman,
I know that, the community resident is just too expensive. I can't.
Yeah.
Would she qualify for TAP funding? Would TAP funding pay for it?
Not the community residential. The only thing they can do is the IOP officer. She'll still have to cover her devices and stuff as well. I don't know.
Yeah, I know that she had a seasonal position and that has ended, so she's not working right now. And obviously she hasn't been working since she's been in custody.
I'm at a loss. I don't know how to go forward.
Okay, well,
But I obviously want to do what they recommend. How the IOP, how intense is it?
She'll go 3 times a week. She'll report to Harris County for the top funded one. And that was for 90 days. And then she'll do SOP for another 45 days, 3 times a week.
Why don't we just do the IOP, SOP, right? And as a sanction, she goes to Hawaii. If she violates, if she messes up, ends up going to Hawaii. But that would definitely, we could make that happen after
We can make
that,
that
right?
happen after.
So we let her know, look, you're recommended to do community residential. Obviously, without insurance, you're not going to be able to pay for it. We'll let you go to IOP SOP because it's basically the same thing, but 3 times a week instead of 4. And we'll pay for it for you. And if you mess up, you're going into inpatient. And just let her know. And if she doesn't want to do that, then just set up a trial.
just volume shooting here. Can we put her on probation and violate her today and send her to Hawaii?
she has to be given like a chance to mess up.
Okay.
Because it wasn't recommended.
Okay,
We have to go with what the recommendation.
Yeah.
Like they didn't recommend Hawaii, so that's.
Okay.
I know that it's probably. And I'm with you,
Okay.
but we can't.
Okay.
So
No, I'm
that's
just.
why we have to.
Just given the time frame everything happened and I have it last, she just doesn't qualify right now.
Okay.
And you're understood, so you would only accept information off all this. Their time, their jail time.
I want her.
Yeah.
I get it.
We just-
I get it. I thought I'd start out there.
Don't want to graduate with going upstairs,
I get it.
Okay.
Let me talk to her and see.
I mean, really, that's a win on your behalf. She's not going to residential or doing anything now. We're giving her the opportunity and hopefully she can, do it the right way. So it's all up to her.
Let me go chat with her.
Thank you.
Thank you.
Right here.
Mr. Lopez, that we talked about a couple of days ago, he's the VOP in our case and picked up a felony VOP. I'm good. You're good. Yeah, you just knock your head. Go with it.
So basically,
Mr. Lopez, you were on bond for a violation of protective order, and I see that you picked up a felony violation of protective order. I warned you at the outset, if you violate this, we can have a hearing to hold you at zero bond. What happened on the felony case, Cole?
On the felony case, on May 4th, 2025, at 4:15 a.m., law enforcement officers were dispatched to the Oxford Inn. The reportee was staying in room 110 and placed a call in regards to hearing screaming, fighting, and what sounded like objects being thrown around the room above hers. The law enforcement officers observed these noises to be coming from room 220. Upon knocking on the door, the defendant answered, and law enforcement officers observed him to be wearing an ankle monitor. Law enforcement officers observed the complaining witness sitting on the bed. Both the complaining witness and the defendant relayed that only a verbal altercation had taken place. Dispatch advised that defendant was currently out on bond in Harris and Fort Bend County, and that the bond conditions in both of these cases included a no contact order with the complaining witness.
He's on bond for a case in Fort Bend County too? What's he got open in Fort Bend?
Check it out, Your Honor. Violation of protective order, AFM.
BPO over there as well? Let's have a hearing to hold him at no bond then.
So this is DBB's case, Your Honor. Before we set anything, I'd like to get DBB in here. We'll email him right now.
When was that case up? Does that case originate from? And is it a felony or is it a misdemeanor?
It looks like a misdemeanor. I'm running the NCIC just to make sure I'm going off the case jacket. So.
Judge, if I may, when they're looking that up, his felony bond is set at 50,000, Judge. He has no intention to bond out. I mean, if you want to go through the, whole thing about your hearing, that's entirely up to you. But I mean, the only thing I would request is, considering this is a misdemeanor and felonies got him at a 50,000, any kind of reasonable bond less than that will solve the whole thing, not waste the court's time. He has no intention to bond out. If you want to no bond him, it's the same situation anyways, Judge. So you could probably save a lot of time and, maybe a $30,000 bond, $20,000 bond, whatever you think is fit. So
Your Honor, as far as what's going on in Fort Bend, I can see there was a AFM filed on, looks like December 20th of 2024. There was an interference call or interference with emergency request for assistance on 12/20/2024 as well at Fort Bend. There was a violation of protective order filed out of Fort Bend on, let's see.
Mr. Lopez, I'm going to revoke your bond now. I'm going to set it at 50,003. And then let's talk to DVD to see whether we have a hearing to hold him at no bond. I mean, I find by clear and convincing evidence, you refuse to comply with bond conditions. You repeatedly show that you're going to do whatever you want to do. You're a complete and utter danger to our community. I think that the only reasonable thing to do is to have a hearing as to whether we're going to hold it no bond. In the interim, now, I'm going to set your bond at 50,003, and then we'll wait for DVD to get here, and then we'll go from there.
Judge, and that's fine, but I am on duty in court 12. I'm not sure when I can get back here.
It's not going to be today.
So,
It's got to be.
No worries. I mean,
I have to give them notice.
And just so Your Honor knows, I'm going to let DBB know, the felony, one of the bases for the two to make it a felony was this misdemeanor, so.
Okay. All right.
And just to let you know, in my discussions, when he understands, he knows the gravity of the situation and his intention.
It's not true at all.
I got you. In terms of all the bonding on that stuff, just so that you have an idea of how you want to proceed with your hearing, we're basically probably going to wait and see what happens in felony, and then this thing will probably resolve itself. Anyways, I just wanted to share that with the court because he and I talked about that this morning.
Just don't send them down, please. Okay.
All right. Thank you, Jack.
Thanks. Hi, Ms. Strong.
Morning, Judge. This is Jonathan Lopez. We have a plea. My
only concern is that he goes back to mom and dad's house now. So what I'm going to do is I'm going to issue a protective order now over the complaining witness now, which is, I don't want you going back to mom and dad's house. You are not allowed to go back. You've repeatedly gone back. I'm issuing a new protective order now. You need to understand that you now you're pleading on this violation protective order. I'm issuing a new one now. If you go back to the house, it's very well possible they charge you with a felony offense. Do you understand? I want to make sure that that family is protected and you don't have any contact with them. So I will accept this plea bargaining agreement today, but I'm now issuing a new protective order today as well that bars you from going back to this house and having any contact with.
Really, the protective order is for his sister, but then the
I thought it was
address
dad.
is the mother's address, so they're kind of conjointly protected in the same order.
Wasn't it? I thought it was dad. It wasn't dad.
The terroristic threat, I think that case involves with the brother and the mother. This VPO was at the mother's address.
Can you file another protective order today, please?
Yes, Your Honor.
In Mr. Lopez's case?
Yes, Your Honor.
So we put the complaining witness in this case as a protected individual and that he cannot go back to the house as well. No listed actions. Mr.
All
Lopez,
of his belongings have been removed from the mother's house, so he understands there is absolutely no reason for him to go back. They're currently at his uncle's house. I will make contact with uncle today to make sure that uncle picks him up upon release.
understand what's happening. What did we just say? Where can you not go?
Back to my mother's house, my sister's house.
Right. What happens if you do?
Oh, basic felony.
Right. Have you been to prison before? Okay, you could be very well looking at a 15 to life case. How many times you been? Once or twice?
Wife.
So you could be a true habitual. You're looking at 25 to life. If you pick up another one, 25 to life as a true habitual. If you go back, do you understand? Don't go back. You're charged with violation of protective order. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 210 days in jail with credit for the 57 days that you have done. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this, it will go on your record. It will be there forever. You understand? Is this what you want to do?
I do.
How do you plead to the offense of violation of protective order? Guilty or not guilty? Guilty. I'm going to find you guilty. I'm going to sentence you to it. I'm going to roll your court costs so you won't owe anything. Deputy Etchegoyen, please do not send him down because we need him to sign the protective order. Okay, all right. Look, all right, you know what's expected. Just don't. I mean, it's really going to be bad if you go back.
Just when you think the hearing is winding down, the courtroom pivots to an entirely different case, this time involving a terroristic threat allegation between sisters. And this is where things get interesting, because not every threatening message automatically qualifies as a criminal threat under the law.
The same in the new protective order.
I think so.
Okay. Okay. All right. Thank you, Judge.
Good morning, Mr. Adams.
Yes, sir. Morning.
Mr. Adams, you're charged with the offense of evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 90 days in jail with credit for the 34 days that you've done. You need to understand that this is an enhanceable offense, meaning if you pick up another one of these, you will be charged with a felony and you will be looking at years instead of days. Do you understand? You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. You're also doing this freely and voluntarily. No one's forcing you to do this. Am I right?
So,
Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? Guilty or not guilty?
good.
Are you sure?
Are you pleading guilty or not guilty to the charge?
Again,
You're pleading not guilty, so you want to go to trial?
good,
Are you sure?
good,
Are you sure?
good.
You really, really sure? Did you run from the cops? I wasn't there. You were there. I don't know.
61 years old.
The age has nothing to do with it.
No,
Whether you ran or not.
You didn't run, you were just on trial.
Did you not run?
I didn't run. I walked out.
Well, I mean,
I'm
tell me what happened.
Your Honor, based on the DIMS,
Well, Mr. Adams, listen, because he's going to say what happened.
3/21/2025 in Harris County, Texas, law enforcement officers were dispatched to a suspicious person call and made contact with the defendant inside an apartment. The suspicious person was someone that should have been in the apartment, that was going into the apartment. Law enforcement officers go out. He identifies himself by name and date of birth. They run him. So he has an outstanding warrant for parole violation or involuntary manslaughter from 1995. When law enforcement officers went to detain the defendant, he took off running. This was also filed as a 2B because he went about 100 yards and they lost sight of him. But they could run him based on his name and date of birth, that this was him that took off.
Is that what happened?
Guilty.
Okay. Are you guilty or not guilty of this offense? I'm going to find you guilty. If you're on probation or parole, you need to understand that by pleading guilty to this, it could result in further confinement.
Yes, sir.
Understand?
Yes, sir.
Still want to do this?
Yes, sir.
Okay, I'm going to find you guilty. I'm going to send you to the green. Good luck to you, Mr. Adams. Thank you. Have a good day. You too. Shh. Sir, you're charged with failure to identify oneself while being a fugitive from justice. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 57 days in jail with credit for the 19 that you have done. You need to understand that this will reflect as a conviction on your record now, and it will be there forever. From now on, you will be facing a minimum of 90 days in jail. Do you understand? Yes or no? Okay. He's also has the assault. Is that one being dismissed? It looks like they're going to dismiss the assault case as part of the agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or challenge this. Is this what you want to do?
Very timely, like I said.
So you want to,
I had no contest initially to that because it didn't make any sense to contest it. Guilty as charged, you know.
on the failure to ID?
I mean, I can't give them something that I don't have. But, I mean, I was in a position. Yep.
Are you guilty of the failure to ID?
Yes, sir.
Okay, I'm going to find you guilty. I'm going to send you the agreement. Good luck to you, sir. Your other case will be dismissed as well.
Okay.
Thank you, Your Honor.
Thank you.
All right. All right, good morning, Mr. Hernandez Ramos. You know, I don't know if you watch the news, but every single day, perhaps every other day, someone dies in our county from an alcohol-related incident. It's so not fair. All you have to do, if you want to get loaded, is hit one button on your phone and you can have a car take you anywhere you want to go for 50 yards. You've now over and over back here for this foolishness. You now need to understand that it's out of my hands from now on. You're pleading guilty to both of these DWIs. They will both be going on your record. If you ever have the faintest smell of alcohol and you come into contact with an officer, from now on, you are looking at a felony offense, a minimum of 2 years in prison, a maximum of 10 years in prison. Is sending you to prison the way that we're going to have to get you to wake up? Look at me. Do you have to go to prison? Is that what it's going to take? All we're asking you to do is don't kill someone, man. Take an Uber. And if you're going to, don't have alcohol in the car. You now stand charged with 2 counts of driving while intoxicated. Both of those are elevated to Class A misdemeanors because of the high blow. You are facing up to a year in jail. The agreement that you have worked out is 60 days in jail with credit for 4 days that you have done on both of those cases. Both of these will be going on your record. So the next time it's a felony offense. Do you understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. By pleading guilty, you can never come back and change this or challenge this. Do you understand?
¿Usted lo entiende? Yes.
This is what you want to
Esto
do.
es lo que usted desea hacer. Esto es lo que usted desea hacer.
Sí.
Yes.
What have you learned?
¿Qué has aprendido?
Nada.
Nothing.
You don't know what you're not supposed to do in the
¿Usted
future?
no sabe lo que no debe de ser en el futuro?
Sí.
Yes.
What are you not supposed to do in the future?
Lo que no debe
I want to make sure that you understand.
asegurar que usted entienda.
Es que no tengo que más.
I don't have to drink.
I don't care if you want to drink.
Si quieres,
I don't care. If you want to drink,
si quieres,
don't get into a car.
mete en un automóvil. Okay.
What did we just learn?
¿Qué aprendiste ahorita?
Es que no tengo que meter, si tomo no me tengo que meter en el,
If I
no
drink,
tengo que manejar.
I don't need to drive.
I'm going to suspend your ability to get a license for 2 years. Do not drive until you get a license.
No maneje hasta que obtenga una licencia de conducir.
Did he say guilty or no?